us today, Mr. Najid. He is the coordinator of IP unit at King Fahd University of Petroleum and Minerals, Kingdom of Saudi Arabia. In his tenure at KFUPM, he has overseen filing of hundreds of patents for KFUPM in various jurisdictions, including US, UK, Europe, and Saudi Arabia itself. In addition, he has successfully licensed and commercialized several KFUPM technologies from engineering disciplines. Furthermore, he received training in IP law from prestigious international law firms such as Evershed LLP in UK, Oblon Speck USA, Lidburn Law USA, Research and Training Institute USA, and from Oxford and University of Manchester. He has a Master of Law LLM degree IP law from Ankara University in Turkey, and he has also an MS degree in architectural engineering from King Fahd University of Petroleum. So I welcome you, Dr. Muhammad Najid. I welcome you on behalf of the Engineering College, on behalf of the entire Aligarh Muslim University. We welcome you to deliver the address, and it's over to you, sir. Thank you very much.
Thank you, Professor Imran, for giving me the opportunity to speak today. And thank you for the introduction. Let us begin. Before I begin, I just want to ask, is my audio clear to you?
Yeah, it's clear. Yes,
Okay,
please go ahead.
okay. So I have structured the presentation as follows. I will start by giving a brief, introduction of intellectual property, basically what, why, and how, followed by a quick review of the global patent statistics, and then I will discuss a typical patenting process in detail. I'll discuss the 9 steps listed here, and I will conclude by discussing 6 court cases regarding enforcement of IP rights. The first question is, what is intellectual property? In simple words, IP is creations of mind, and creations could be of many types. They could be inventions, for example, machines, products, processes, or creations could be literary and artistic works, such as books, music, movies, or creations could also be designs or symbols and names and images used in commerce. IP could be as complicated as an IC engine or a vaccine for a disease, or IP could be as simple as sticky notes or process of making cornflakes. So a large variety of creations fall within the scope of IP. The second question is, why should we seek IP protection? First is, IP provides protection to the creator, and that allows the creator to get a reward for his invention. For example, scientists put in a lot of work in developing inventions, let's say vaccines or medicines. And if their inventions are stolen by third parties, there is no motivation for them to keep on working. So it is necessary that we protect our IP so that the inventors get reward for their hard work. And in addition to that, there is, of course, encouragement and growth and recognition aspect as well. Now, we discussed in the first slide that there are many kinds of creations, and to protect those different kinds of creations, we have different kinds of IP rights. The first and the most common is patents. Patents are used to protect intellectual property. For example, inventions such as a machine or a product or a process. Patents protect the functional aspect of a patent, the science behind the invention. And patents are valid for about 20 years from the date of filing. The other intellectual property is industrial designs. Patents cannot protect designs, so there's a separate category for protecting designs. It's called as industrial designs or design patents, as they are called in the US. And design patents are valid for about 14 years from the date of filing. The other type of intellectual property is trademarks. trademarks are used to protect business marks or marks which represent businesses. For example, Coca-Cola is a trademark, Apple is a trademark. So these kind of intellectual properties are protected through trademarks. The next is trade secrets. Trade secrets are used to protect creations which the inventor does not want to disclose to public. For example, Coca-Cola has existed for a long time, but it hasn't filed any patents or industrial designs or trademarks for its formula. So the formula of Coca-Cola is kept as a trade secret, and trade secret protection allows Coca-Cola to keep its formula secret and not give it to others. The last one is the copyrights. Copyrights protect creations such as books, music, movies, etc. So literary and artistic works. These are the main types of intellectual property. There are few other, but we will not discuss them in this session. And in this session, we'll focus mainly on patents. But before we discuss patents, let's see what's happening around the world. Are people actually filing patent applications? As you can see in this chart, the highest number of patent applications are being filed in China. These are statistics from 2018. So as you can see in China, about 1.5 million patent applications were filed, which is quite a huge number. After China, the second highest patent applications were filed in the US, around 600,000, which is also quite high, followed by Japan with 300,000, Korea 200,000, and EPO around 170,000. Number six is Germany, and number seven is India. So India has broken into top 10 with around 50,000 applications in 2018, and I'm sure in 2019 and 20 there must have been significant growth, and the numbers are even higher. So this statistics shows that around the world, a lot of patent applications are being filed by the inventors to protect their inventions. Let's look at a typical patenting process and see how the process takes place. First is the invention disclosure. This is the point where an inventor goes to the look to its own patent office, to his university's patent office, and tells the office that I have an invention and I want to disclose it. So this action is called as the invention disclosure. This is followed by due diligence and patentability search. So once an inventor discloses an invention to a university's patent office, the patent office does its own due diligence and search to see if the invention qualifies to be a patent. Does the invention satisfy the criteria to get a patent? If it does not, if it is found by the patent office that the invention is not new and someone else has already made such invention, then the inventor is asked to revise his invention or improve his invention so that it becomes patentable. But if prior art is not found, and if it is found that the inventor satisfies the criteria to get a patent application, then the next step is to prepare a patent application. I would like you to understand that. So when an inventor discloses an invention to the patent office, it is written in generic English, the English we use daily. But every patent office has certain criteria for submitting before submitting a patent application. So a patent application has to be rewritten in the format required by the patent office. This step of rewriting the application from generic English to the language required by the patent office is called as preparing patent application. This is usually done by registered patent attorneys or patent agents. And if an inventor has experience in writing a patent application, he or she can himself or herself do this part. And as you can notice, so far from the invention to the preparing, from the invention disclosure to the preparation of patent application, this part is all in-house. We haven't yet reached the patent office. We have disclosed the invention, done some due diligence and searching, and prepared the application. After going through these stages, the invention is filed in the patent office, which means that you submit your invention to the Indian patent office and you say, this is my invention and I want a patent for it. So what the patent office does is, after filing, the patent office first publishes it after 18 months from the date of filing, and then examines the application. And if the patent passes the examination, it is granted. If not, it is rejected. And there is also a scope to appeal against rejection if you would like. And in the end, there is maintenance. So we will look at all these steps in detail one by one. So step number one is invention disclosure. These are a few questions which are commonly asked by students in my university. So I thought of putting them here and answering them so that you get an understanding of what an invention disclosure is. So invention disclosure is, as we discussed in the last slide, it's a disclosure of an invention by a student or faculty to the IP office of the university. What is an invention disclosure report? It is a confidential description of invention described by the inventor, which is submitted to the university IP office, so that the IP office can protect and commercialize it. When is the right time to disclose an invention? This is a very common question we get asked every day. When should the students and faculty ask, when should we disclose our invention? When is an invention ready to be patented? So the answer is, as soon as you determine that your invention is patentable and it may have commercial value, you should go ahead and submit it to the IP office of the university. And please note that the invention does not have to be market ready, or it is not necessary that the invention should be converted into a fully developed product or a process. As soon as you have the idea and a little bit and a little information about how the idea works, you should disclose your invention right away. And what should the invention disclosure report include? In brief, it should include as much information as you can. For example, the science behind the invention, which shows how the invention works, advantages of the invention over existing products or processes, its drawbacks, and its scope of use. For example, where can it be used in the industry? After answering these questions about invention disclosure, next is inventorship. It is important to note that an inventor is a person who makes intellectual contribution in the development of an invention. I have put this here because in universities, when a group of researchers work together, then there is a tendency for those researchers to put all of their colleagues' names as an author if they are going to publish an article in a journal. But that same principle of authorship does not apply here in the patent law. So you cannot, a person or a student cannot include his friends and colleagues as an inventor just because he worked with them. To be included as an inventor, a person should have made intellectual contribution to the development of the idea. And this problem with inventorship happens mainly when there are multiple inventors. And please note that if an inventor is named incorrectly, it results in the patent application being rejected. And some of the common inventorship errors are uh, students and faculty tend to nominate a person as an inventor who is actually not an inventor. So it's a misjoinder. Or for example, they fail to name a person who is an inventor. It's called as non-joinder. These are the two common inventorship errors that happen, and sometimes the inventors lose the right to a patent. But if you have made a mistake in adding or skipping an inventor, it is possible to correct the inventorship through the process specified by the patent office of the country. And in many countries, inventorship has strict legal meaning. For example, in Saudi Arabia, where I work, the Saudi patent law specifies that an inventor is someone who participates in the invention. He cannot be someone who just helped in doing some tests or just prepared the report or does something which does not relate to the invention. So the person should participate in the invention to qualify as an inventor. And in the US, the US patent law describes an inventor as an inventor must contribute to the conception of an invention. Again, the same thing but written in different words. And in Europe, uh, an inventor is someone who should have made a certain level of contribution to development of creative elements of an invention. So an inventor is someone who should have made some kind of creative contribution to the development of invention. As you can see, all around the world, inventorship has strict legal meaning. Let's look at an example. This is from the USA. This example shows what happens if you fail to name an inventor in a patent application. So Jeff Verhoff is a person who is a dog owner. So he developed a leash for his dog. It looks something like this, and in, he developed it in coordination or in cooperation with his veterinarian, Dr. Alicia Lamb. So the original idea of the leash belongs to Jeff, but Dr. Alicia nominated or she contributed the 8 kind of design you see in the leash. So, but the bottom line is both inventors developed this invention together, and they went ahead and they filed a patent application in the US Patent Office with Dr. Lamb and Jeff as the co-inventors. They were named as two inventors. But after some time, there was a conflict between them, and Jeff abandoned the joint patent application, and each inventor went ahead and filed separate patent applications. Jeff filed a separate patent application in the US Patent Office, and Dr. Alicia did the same. When the patent application of Jeff was being examined, the examiner came across Dr. Alicia's patent application, and based on this, the examiner found that Jeff is not the sole inventor, so his application was rejected. He went to the Patent Trial and Appeal Board to appeal against the rejection, but his appeal was rejected. So he further went and appealed in the Federal Circuit Court, and the court again rejected his appeal, saying that since you are not the sole inventor, you won't get the patent. So both of them lost their patents because of their disagreement, and mainly because one inventor left the other inventor out. And as per US patent law, if you don't name an inventor, you lose a patent. And it is same in many other countries. So this was about inventorship. So, so we have discussed patents, but let's see what is the criteria to get a patent. I have tried to make a comparison between 3 countries, India, United States, and Europe, and let's see what each of them say. The first criteria is novelty or new. All 3 countries have this criteria in their patent law. A novelty means that the invention should be new and should not have been available publicly before the filing date of the invention. This proves novelty of the invention. The second criteria is inventive step. In India, this step is called as inventive step, whereas in US, the same criteria is called as non-obviousness. And in Europe, it's also called as inventive step. So what is inventive step? Basically, it shows that a person who is an expert or an ordinary person in the art, for example, if someone developed an invention in the field of mechanical engineering, then if an ordinary mechanical engineer looks at the invention, it should not look obvious to that person. Which means that there should be significant technical development in the invention when compared to the prior art. Third is industrial application. The third criteria is that the invention should have an industrial application. The same criteria in the US, it's called as usefulness, and Europe calls it industrial application. So these are the three main criteria for getting a patent, and but there are two more. For example, the fourth one is a statutory subject matter, which means that the invention should belong in the subject matter specified by the patent office. For example, Indian patent law states that the invention should be either a product or a process. The US patent law describes it in much more detail. For example, US patent law says that the invention could be a process, a machine, an article of manufacture, a composition of manufacture, or an improvement of any of these four categories. Whereas the Europe makes it very simple. It says the European patent law says that invention must belong to any field of technology. And the last criteria is specification. The Indian patent law says that the patent application should have enough specification, which means enough details, so that when a person reads the patent application, he or she should be able to create the invention without undue experimentation, which means that an inventor has to describe his invention in so much detail that if a person reads the patent application, he should be able to produce that invention. The same criteria in US is called as enablement and definiteness. Different name, but same explanation. And the Europe calls it enablement. So these are the 5 criteria for getting a patent. Let's see which criteria causes most rejections. This is a survey from the US Patent Office between 2005 and 14. It's a little bit old, but still gives an idea about which criteria causes most rejections. As you can see from the graph, the non-obviousness criteria um, accounts to about 66% of rejections, which means that in all these applications, when the examiner reviewed the application, it looked obvious to him. The examiner felt that there was not enough technical development in the invention. Of course, we will see in the future, even in the next slides, that you can appeal against rejections. But as you can see from this slide, 66% of the rejections were based on non-obviousness. The second highest was new or novelty, which means that 37% of the applications were rejected because they were not found to be new, which means that when the examiner was examining the application and searching for prior art, he or she found that the same invention was done or developed by someone else in the past. So based on that evidence, about 37% of the applications were rejected. The next is enablement and definiteness, which means that which means that inventors were unable to describe the invention in sufficient detail, and hence their applications were rejected. And the last one was subject matter. If we go back one slide, um, the third criteria was industrial application. So, um, and when you come back to this slide, you will see that there have been no rejections about industrial application. So, it is we can say that very few or no applications are rejected because of not having industrial application. It is really easy to prove that an invention has industrial application. So this was about the criteria which causes most rejections. I've also included this slide to show that some types of inventions will not qualify for the patent even if they fulfill the criteria we discussed just now. For example, mathematical formulas, laws of nature, newly discovered substances, but they occur naturally in the world. If someone discovers something that naturally exists, even if it's really interesting, it's not possible to get a patent for it. And the next one is purely theoretical phenomena. So we cannot get a patent for a purely theoretical phenomena. Um, in addition to these categories, some other inventions do not qualify for patents. For example, processes done entirely by human motor coordination, a dance choreography or method of meditation cannot be patented. most protocols and methods to perform surgery on humans. Of course, if you patent a process to do a surgery, then it may cause issues in the medical field. So they are the inventors cannot protect the process to do a surgery. And printed matter that has no unique physical shape or structure, unsafe drugs, inventions useful only for illegal purposes, and non-operable inventions, example, perpetual motion machines. So far, we discussed step one, invention disclosure, and we looked at many different aspects of an invention disclosure. The next is prior art search. When a student or a faculty submits an invention to the IP office of a university, the first thing they do is perform prior art search. Prior art search is done by the IP office to see if the invention is novel or not. The IP office wants to see if someone in the past has developed the same invention or not. As I said, it can be done in-house by the IP office, or there are independent prior art, there are independent offices who do prior art search for inventors. So that is one option. The inventor can make use of that. And if prior art search is found, if it is found that the invention is not new and someone else has done that in the past, then the only option for the inventor is to modify his invention to make sure he overcomes the prior art. And if nothing is found in the prior art search, then a patent application can be prepared and filed in the patent office. These are some details of prior art search. There are different kinds of prior art search that you can do. Patentability or novelty search, which is done mainly to make sure that there is no prior art for invention and a patent can be filed. The second type of prior art search is freedom to operate. This type of search is done to see if a patent uh, can be created or manufactured or commercialized without infringing other patents. So this is a freedom to operate search. There is validity invalidity search. This is done mainly in cases where a patent is challenged, or if an infringer wants to invalidate a patent, the infringer gets this search done to validate the patent so that there is no infringement left. There are some other kinds: state-of-the-art search, technology landscape search, and some other searches. But mainly for students of AMU, I think the patentability search is the most important, because that helps in determining the novelty of the invention. Um, I have put some examples here to show that sometimes when a patent application is being examined by an inventor, by a patent examiner, the examiner can use unusual references to reject a patent application. For example, for a US patent application, the invention was a three-pronged fork, as you can see here in the image. So what the patent examiner did was, when he was doing prior art search to examine the invention, he found a cartoon which displays an image which was similar to the invention. So the examiner rejected a patent application based on a cartoon video. So it is not very common, but it does happen. The examiners can use unusual references to reject patent applications. This is the US patent, as you can read here. If the text is readable, you can see the examiner cited that SpongeBob SquarePants episode 1, Help Wanted, air date 1999, was cited as a prior art. Yeah, this is an example for a UK patent. On the right side, you will see that UK publication number GB2273053. This patent application, which was filed in 1992 and published in 1994, was rejected by the patent examiner based on the scene from the movie. The drawing from the patent application on the right looks similar to the image you see or the device used in the image by this actor. So this patent application was rejected based on a scene from a movie. So another unusual reference used by the patent examiner. And this is the actual snapshot of an actual patent application. As you can see here on the right side, the examiner clearly specifies that film or video titled Thunderball United Artists and featuring the fictitious character of James Bond, particularly the scenes depicted in the video at 65, 90, and 125 minutes from the start. This is very specific. The examiner has pinpointed the scenes where this device was seen, and based on that, he rejected the application. One other example is of turmeric. Many of you may know that turmeric is used in India for wound healing, and uh, University of Mississippi Medical Center in the US filed a US patent application in December 1993 to protect uh, turmeric to be used for medicinal purposes. In fact, the patent was granted in 1995 and the number is 5401504. But in 1996, the novelty of the patent was challenged by the Indian Council of Scientific and Industrial Research. So this council challenged the US Patent Office, challenged this patent in the US Patent Office and said that this university cannot get a patent for turmeric because in India it is being used since a long time and it is very well known knowledge. So based on the challenge by the Indian Council in 1997, the application was rejected after re-examination. So the University of Mississippi was unable to get a patent for its invention. This is another example of how prior art can result in rejection of patent applications. So what I wanted to show in these three slides, an example is if you have an invention and if you want to get a patent for it, make sure you do a thorough patent search. You don't have to go to a professional. You can start by doing a Google search. If you just type the keywords of your invention in Google, you will know if your invention is new or not. If you don't find any references, immediately go ahead and disclose the invention to your university's patent office and they will get a patent for it. But it's necessary that you do a thorough periodic search. But where to do this search? The highest number of searches are being done in patents, which means that 57% of the searching for prior art is done in patents. About 23% in academic journals and 7% in non-academic journals, for example, trade journals. And 7% of the searching is also done in conference proceedings, followed by 5% in news articles. So these are the top 5 venues where prior art searches is done. Now we have finished step one and step two. Step one was the patentability criteria and a little bit about the invention. Step two was about prior art search. Now, step three is patent application. As I said in the beginning of my presentation, the invention you have with you is described in common English, but it has to be converted into a formal patent application by either registered patent attorneys or patent agents. And they rewrite the invention and they have this 5 or 6 main parts in the invention. The first is in the patent application. The first is the title of the invention. Many patent offices want the title to be described as brief as possible. It should be concise and brief. Once after the title is decided, the next is abstract, a brief summary of the invention, followed by a full description. Always ensure that you include as much information as possible in the description of invention so that the application does not get rejected by the patent examiner due to lack of specification. The next is claims. Claims is the most important part of a patent application. It is within the claims that you describe what your invention is. And what is written in claims protects your invention. So it is really important to write the claims in the way that uh, broadly covers your invention. The last one is drawings. Of course, if there are drawings which are accompanied by the text, you should put all of them and make sure that they sufficiently help in describing the invention or understanding the invention. So this was part three, preparing patent application. So once you reach this stage, once you have your patent application ready, you should file your application. But before speaking about filing of patent application, I just want to tell you that so far from step one to step three, all of this work was done in-house, which means it was done by the team of inventor and patent attorney or patent agents. We haven't yet reached the patent office yet. So we reach the patent office now and file a patent application. But before we discuss patent application filing, let's have a quick look at an example. I think everyone is quite aware of Nokia being sold to Microsoft, but what's not common is the amount of money paid by Microsoft to Nokia was around 5.44 billion euros, and around 3.79 billion was for the actual business of Nokia. For example, the mobile phone and smartphone devices and certain support assets. But about 1.65 billion euros was for utilizing the patents of Nokia for a 10-year period. So this deal between Microsoft and Nokia shows that patents form an important part of business and they have a significant value. So let's see about filing a patent application. Where to file patent application? Of course, every major country has its own patent office. India has its Indian patent office, and Saudi Arabia has Saudi Arabian patent office. So that is one of the options. You can file in the national patent office. And the second option is regional patent office. For example, Europe consists of many countries, and the European Patent Office is the regional office which provides protection in all of those countries. For example, if you file one European patent application and if it's granted, it gives protection in all countries of Europe. And there is a GCC patent application, GCC regional office, which provides protection in 6 countries. There are a couple of regional offices in Africa, and there is the Eurasian patent office. So you have the national patent office, you have the regional patent office. The third option is a PCT application. A PCT is a treaty, international agreement that was signed by many countries and was done in 1970, and it is administered by the World Intellectual Property Organization, WIPO, which has headquarters in Switzerland. And the aim of the PCT is if you file a single patent application, it provides protection in 153 countries. But this protection is temporary. It's only for 18 months. It does not provide protection like 20 years, which is given by the national patent offices. So it's a temporary protection. But why do we need PCT? Let's look at an example. If I have an invention and I believe that it has market in Saudi Arabia, so I will file an application in Saudi Arabia. But if I believe that it has market in other countries as well, India, let's say US and the UK, but I do not know exactly where the market is, and I need time to do my market analysis. So instead of rushing and filing the patent application in many other countries and incurring lots of expenses, what I will do is I will file a PCT application, which will give me 18 months time to do my analysis and decide where to file an application. So I have protection for 18 months, and then when I've made my decision, I will go ahead and file individual patent applications in different countries. So this is the value of a PCT application. So far we have filed the application. What happens after filing? After 18 months from the date of filing, the patent office the patent office makes the patent application publicly available. For example, if I file an application today in the Indian Patent Office, the Indian Patent Office will keep it secret for 18 months, and after 18 months, it will make the patent application available publicly. But there are some exceptions to this publication. If the patent application is a matter of national security, then it's not published, or the publication is delayed, or if it's a provisional application, or if it's a design patent, it's not published. And this is an example of a US patent application. On the left, you will see the date of filing, and on the right, you will see date of publication, which will be 18 months from the date of filing. Next is examination. Once an application is filed and published, the patent office examines the application. There are two kinds of examination. One is formal and another substantive. In formal examination, the examiner checks the details like applicant's name, description, priority date. Is the application excluded from patentability or not? Does it have industrial applicability? Are the claims properly written? The drawings are in good condition, and the inventors are named properly. These are all formal examination. The next part is substantive examination, where the examiner does novelty search and search for inventiveness. So this is done through the search of prior art. So this is a brief process of the examination. So you file an application, it goes to the examiner. The examiner, if during the examination, if the examiner finds that the invention is not new, or it is an obvious invention, then it is rejected. This rejection, this communication between the examiner and the inventor or his or her attorney is called as office action in the US. In India, it's called as the examination report. Once the patent office issues the examination report, the inventor can review the report and file a response to it. And if the examiner is satisfied with the response, the patent is granted. And in the US, you get 2 rejections per applications. After 2 rejections, the applicant has to pay additional fees. And in India, about 50% of the examined applications are granted directly after a response is filed. And for the remaining 50%, they go through the oral hearing process. So it is possible for the inventor or his or her attorney to have an oral discussion with the examiner to discuss his rejections and get the patent granted through it. And once the patent is allowed, once the patent application passes the examination, it is allowed and finally granted. This is an example of the Indian patent. As you can see, the first detail you see is the patent number, followed by the application number and the date of filing. The fourth option is the patentee, which is the owner of the patent. And in the bottom, you will see the bottom paragraph, you will see that the title of the patent is mentioned. And it is also mentioned in the second line from below that the above mentioned application is valid for the term of 20 years from the date of filing. So the life of the patent is 20 years from the date of filing. And there is also a scope for pre-grant opposition, which means that once a patent application is published, any person or a third party, a company or a government, can challenge the validity of the patent by submitting a written application to the Indian Patent Office. So let's say I own a company which works in a certain field, and I came across a patent application which is owned by my competitor. So what I will do is, as soon as the application is published, if to protect my business, I will go ahead and file a pre-grant opposition with the patent office and challenge that a patent is not valid. There are several grounds for filing a pre-grant opposition. For example, wrongfully obtaining the invention. If a competitor wrongfully obtained the invention from a company and went ahead and filed an invention, then the original owner can claim or can challenge the patent by filing a pre-grant opposition. Anticipation by prior publication. If a person finds that this invention is disclosed somewhere, then that person can give that documentation to the patent office and show that this application does not qualify to become a patent because there is prior art. And there are several other uh, grounds based on which you can file a pre-grant opposition. And there is also a post-grant opposition, which is filed after a patent is granted. So once a patent is granted, if a person who is interested in filing a patent wants to challenge the patent, it can do so by going ahead and filing a post-grant opposition in the patent office. So it is possible to challenge a patent before it is examined and after it is granted, which is called as pre-grant and post-grant opposition. Patent rejection and appeal. As I said in the beginning of my presentation, once an application is rejected by the patent office, it is possible to either appeal against the decision to the Intellectual Property Appellate Board, or you can ask the patent application, you can ask the patent examiner to review the application again. So both options are possible. You can appeal against, you can appeal to the board, or you can ask re-examination of a patent rejected patent application. So once we have crossed all of these stages, and if a patent is granted, then it does not automatically remain for the life of 20 years. For example, as per the Indian patent law, once a patent is granted, maintenance fee starts in the second year of the grant, which means for the third year of the patent, you have to pay a maintenance fee. And after that, every year, a maintenance fee has to be paid to make sure that the patent remains valid. In USA, after a patent is granted, maintenance fee has to be paid at 3.5, 7.5, and 11.5 years after the grant of the patent. And in Saudi Arabia, the process is similar to India, where the fees has to be paid annually. Please remember that failure in payment of maintenance fee results in the abandonment of patent. And if a but sometimes if a patentee sees that there is no value in maintaining a patent, it can refrain from payment of maintenance fee and the patent gets abandoned. So I had to rush through the previous few slides because we are almost at the close. But I have these 6 or 7 slides left, which are case studies. We will quickly go over them in 5 or 6 minutes and then open the floor for question and answers. Before we look into individual court cases, let's see what happens in enforcement of IP. Like for example, if you get a patent, it is not guaranteed that no one will challenge the patent and you will have it for the life of the patent. For example, the first litigation case was between Idenix Pharmaceuticals and Gilead Sciences. In this case, the initial damage awarded by the court in the US was 2.5 billion US dollars, which is quite a lot of money. And similarly, in the second case, if you look at the Centocor Ortho Biotech versus the Abbott Laboratories, the initial damage awarded was $1.6 billion. So again, quite a lot of money. And in the next few cases, you will see the damages have been upwards of $1 billion. And in the below fair cases, close to $500 million. So in litigation, especially in the US, huge amounts of money is involved. Let's look at the first infringement example. It is between a university and a private firm. Carnegie Mellon University is a US university, and it had 2 patents which it believed were infringed by Marvell Technology. Marvell Technology is a company which manufactures semiconductors, and they make integrated circuits for computers, mobile phones, and home appliances. The technology which Carnegie Mellon University owns was alleged to be used in about 2.3 billion chips. So if Carnegie Mellon is successfully able to uh, prove that Marvel infringed their patents, then they'll have to pay for selling 2.5 to 2.3 billion chips. Let's see what the judgment was. The jury awarded damages of about $1.17 billion. This was the third largest ever patent case at that time. And the reason for giving such a huge award was the jury found that Marvel intentionally or willfully infringed the patents of Carnegie Mellon, and that is the reason why the judge awarded the damage, which was up to 3 times the original damage amount. But eventually, Marvel and Carnegie Mellon settled the case, and Marvel paid about $750 million to Carnegie Mellon University. So these two patents brought in a lot of money for the university. Let's look at second example, Idenix Pharmaceuticals and Gilead. So Idenix Pharmaceuticals, they own a patent 7608597, which is used for treatment of hepatitis C virus. And Gilead is a company which creates a drug called sofosbuvir, and Idenix claims that this sofosbuvir drug um, contains or infringes their patent 7608597. And the initial damage awarded to Idenix Pharmaceuticals was in excess of $2.5 billion. But Gilead did not make this payment. They went to a higher court, to the federal court, and they challenged that the patent itself is invalid. And they were successfully able to prove that. They were able to invalidate the patent. So if there is no patent, there is no issue of infringement. So the federal court dropped the ruling made by the district court and agreed that the patent is invalid. So in the first example, we saw that the patent was not invalidated, and Carnegie Mellon University was able to get huge amounts of money from the infringer. Whereas in this example, we see that the patent did not hold, and it was invalidated, and hence Gilead had to pay nothing. So from these two examples, we can conclude that when you write your patent application, or when a patent attorney writes a patent application, the inventor has to ensure that the patent covers all aspects of the invention, and it's a airtight patent. The next couple of examples are for copyright infringement. Oxford University Press, Cambridge University Press, and Taylor Francis. These are three book publishing companies, and they claim that a photocopying center, Rameshwari Photocopy Center in New Delhi, has been illegally photocopying the contents of the books and distributing it to the students. So the three publishing company went ahead and filed a case in the Delhi High Court, but High Court dismissed the case based on the ruling that the course pack was made in the interest of students, so that they can gain knowledge. And based on the court said that everyone should have access to education. Different people in the IP field have different opinions about this case. Some believe that it is unfair for the three publishing companies, that their books were being illegally copied and they were not getting paid for it. Some people argue that it is fair. The judgment was fair and students should get access to education. Anyway, there are different opinions available, but the High Court decision was in favor of Rameshwari Photocopy Services. And this example is also about a copyright example. On the left is a photo that was taken by a freelancer called Manny Garcia, and who used to work as a freelancer, and but the photo was for Associated Press. And someone called Shepard Fairey created a poster which was similar to the photograph that was taken. So, and this case was taken to the court, but a private settlement was made by the two parties, and they decided to split the profits for this work. So we have seen one example where the court ruled in favor of the defendant, and this in the second example we are seeing that it is also possible to settle out of court and take find a path which is good for both the parties. The next two examples I'm going to speak about are about trademark. CTS is a company based in the US, and STC is a telecom company based in Saudi Arabia. About an year ago, STC launched a new logo, which you can see on the right. But after the launch, it was found that the logo looked quite similar to the logo of a company called CTS. So CTS tried to speak to STC that they have copied their logo, but since they got no answer, CTS Corporation went ahead and filed in the beginning of 2020 an opposition proceeding with the Saudi Authority for Intellectual Property, claiming that STC has infringed their trademark, which is causing huge losses to their businesses. The case is still ongoing with the SAIP, and let's see what the decision will be. But it is also possible to file a case against trademark infringement. This is my last slide of this presentation, and it is also a trademark example. Yambu Steel is a company which is a company in the Saudi Arabia, and they ordered pipes to be used in oil and gas industry from an Indian company. When the Indian company represented themselves as an affiliate of Nippon Steel, although they had nothing to do with Nippon Steel, but they got the project by showing that they were affiliates of Nippon Steel. The Indian company delivered the pipes, and on the pipes they printed Nippon Steel, the fake trademarks. And when Yambu Steel Company tested the quality of the pipes, they were not up to the standards required by them. So what they did was, instead of going to the Indian company, they went ahead and complained directly to Nippon Steel. Nippon Steel said that we do not have any association with this Indian company. So what Nippon Steel did was they filed a case of fraud in the court, and they claim that this Indian company duped the plaintiff by using their trademark illegally. The court found this allegation to be true, and they ordered the company to pay a fine of around 2.6 million riyals. So it is also possible. We see in this example that it is also possible to file a case against trademark infringement. So this concludes my presentation. I went a little bit over the time limit, but I would be happy to answer any questions any of the attendees have. Thank you.
Can I have Imran, I have a question if you allow me.
Yes, Asad Saab, please go ahead. Professor Asad from Biotechnology Department, please go ahead.
Thank you, Professor Sufyan Saab. Thank you. Okay, it's a very, very nice talk and well explained about the patenting. I do have a question, Naji Saab, that I mean, it's my own personal example. Suppose I've got an invention and I have already submitted that invention to a journal. Although it has not yet been published or even not peer reviewed, it is just with editorial. And in the meantime, I thought to file a patent, although I have already prepared the patent forms and everything ready. And then I submitted the patent as well. Now, in case if a patent goes to examine, he or she will not find my patent anywhere in the public domain. because the paper submitted is not yet published, not in public domain. But in case if paper published as well, fortunately, and my patent is also in process of examining and going through process of publication, then I think if finally my paper accepted after 6 months before the patent application number, would it be any problem in patenting finally granting or not?
Yes, in some jurisdictions like Europe, where there is absolute novelty, if your paper is published before your date of filing, then your own paper will be the reason for rejection of your patent application. But if your application is filed before the publication of this paper, then it should not be a problem.
Okay, so
Because the date of filing.
my next very critical question. Well, paper will be published maybe in a 6 month, and I have already filed application before 6 months. Okay, but when the paper come out from publishing company, mentioned clearly that the date of submission, date of revision, and date of publication. So would it be any problem for the patent office to see if the paper was submitted even before the patent was filed?
Date of submission and date of review do not constitute public disclosure. It is only the date of publication which is considered as the date of the public disclosure. So it should not be a problem. As long as your date of publication is after the date of filing, it should not be a problem.
Thank you so much. Thank you so much for answering. Thank you so much.
You're welcome.
Do we have any other questions, comments from the participants, please?
Yes, we can have questions. We have already reserved 15 minutes for the question and answer session. So we welcome any question from the audience. There are some faculty members also.
Okay, I have a critical question, Mohammad Najid, a very basic one, in fact. I'm Professor Sufyan Beg, I'm the principal of the engineering college. What I would like to, it's more of a comment rather than a question. Don't you
Okay.
think that dishonesty is the basis for all the IPR exercise? People are being dishonest. That's why you have to get the patent rights and all. If people had been honest, all these IPR things would not have been required. What do you think?
I don't think it is dishonesty all the time. Sometimes people just get inspired by seeing an idea. You are correct to an extent, but that is not the case all the time. For example, if you take research at the university, most of the research is basic research and it is incremental research, and many researchers get their inspiration from previous research done in the field. Of course, the researchers add their own ideas, but a lot of inspiration is from previous work. So the intellectual property, I believe, what it does mainly is it rewards whoever creates the invention. For example, if I create something, but it is not of much commercial value, and if someone takes my invention and develops it further and goes ahead and files a patent application. Although his work is based on my work, but he still added substantial value to the work, and to make sure that it goes ahead and gets commercialized and we get value out of the patent. So, in summary, what I would like to say is there is some dishonesty. That is why the intellectual property regime had to be made, but it is not correct all the time.
Okay, thank you very much. I agree with this. Now, my second question is, after you have got your patents granted, how do you actually attract the revenue generation out of it? I mean, what should be the practical way? You touched upon it, but what should be the practical way of getting in of attracting revenue generation?
Okay, once like an inventor gets a patent, getting value out of it is more of a business thing, you know. Uh, a lot of marketing is involved. So what we do at the university is, once a patent is filed or granted, we take that patent and go and present it to the local industry here. We go to relevant companies, make a presentation, explain what the patent is. If the company finds the patent to be of interest, then they license the patent from us. But if some development is needed, the university and the company together develop the invention and then create it into a product. So to answer your question, to get value of a to get the value from a patent, a lot of marketing and commercialization work is required.
Thank you very much. Any
Sir,
more questions?
yes, sir. We have a question from our audience. She asked the question that can you please put on your perspective on that Delhi High Court judgment on that copyright case. Your take on that.
Uh, my opinion, many of you may not agree with it, but I believe that it was unfair. It was unfair for the publishing houses that their work was being copied. Their work was being, copied illegally and being distributed to students. What I believe is, if the court believed that the students could not afford such expensive books, maybe the government could provide a subsidy, or the university could, provide a subsidy to the students so that they can get they can get the books at a lower cost. But completely telling the publishing companies that the photocopying center can go ahead and copy the content from the book without giving any royalty to the publishing company is a little bit unfair, because it has now created a precedent where uh, the other photocopying companies and the other universities will just go ahead and keep copying books, and nobody will buy the books. Maybe just one person from the class will buy the book and rest of them will photocopy. So it could be quite dangerous for intellectual property laws, and it may discourage many large companies from exporting their books to India or creating their businesses in India. So it has its disadvantages, but from the student's point of view, one can say that yeah, the students could not afford it, so it is a fair decision. But in my opinion, to the court should have upheld the IP laws and should have stopped illegal copying of the material from the books.
Can I ask a question?
Please go ahead.
Yes. I am Professor Amir Azam in the Department of Applied Physics. I have two questions. The
Okay.
first question is, what is the best method for prior art search? It is only a Google search, or there are some other specific website which can be utilized for search?
Let me also inform the audience that Professor Amir Azam has recently got his patent granted from the Indian Patents, office on nano composite materials. Am I right, Professor Amir Azam?
Yes, sir.
Yeah. So in that light, his question may be addressed, please.
Okay. So first of all, congratulations, Dr. Amir, on getting a patent.
Thank you.
To answer your question, there are several paid databases available which can be used for doing prior art search. For example, there is one by Thomson Reuters, and there are many which are based in India as well. PatBase, PatSnap. What these patent databases do is they make searching easy, and they have patents from all different countries around the world. So you'll be able to do a much better search if the search is done in these paid databases. But they are quite expensive, and if the university can subscribe to them, that would be much cheaper. But if an individual wants to go and buy that, they are quite expensive. An alternative to the paid databases is the free databases available online. For example, free patents online, the European patent search engine, eSpaceNet, and the US Patent Office also provides a free search engine. So these free patent databases is the second best option, and the third best, as you said, is Google. So if I have to rank them, I will say that the best option, top option, is to search in paid patent databases because they are quite comprehensive and they include a lot of information. The second is free patent databases. The third is Google search.
Okay, thank you. The second question is if I have a Indian patent, can I file it in another country also?
Yes, within 1 year of the date of filing of the Indian patent, you can file in other countries based on Paris Convention. There is a convention called Paris Convention, and almost all the major countries of the world are part of this convention. And Paris Convention allows filing of a patent application in other countries within 1 year of date of filing of your Indian patent application. But since your patent is granted and published, it is really difficult to get patent in other countries because your patent is now publicly available. And when you go ahead and file in, let's say, US, your own patent will act as prior art for your patent in the US. So the decision to file in multiple countries has to be made at the time of filing of patent application. Waiting till grant is too late.
Okay, thank you very much.
Are there any more questions, please? I can see my classmate Vijay Bhartwal here. He may have a question too because the kind of eager person that he is. Vijay, are you there?
Yeah, Sufyan, thank you. In fact, I was trying in between, then very interesting conversation taking place between someone who has been granted an Indian patent and looking for international patent. So I just stopped and started hearing that. But I think initial 10 minutes I missed of the discussion when for this presentation. So I might have missed it. So my simple query was, have publishing something in a journal and then converting that into a commercial intellectual property. I mean, what I understand is becoming a contradictory in itself. If you are creating a commercial IP, then you should not publish it in the academic journal. Is it so?
Yes, it is correct. The best option is to file a patent first and then publish. Uh, because many countries ask for absolute novelty, which means that once you publish a patent, once you publish a paper in a journal article, you lose the right to get a patent. So many countries do that. But some countries like US provide 1 year grace period. So if you have published your paper today in a journal and you want to file a US application, you can still do that up to 1 year from the date of publication. But you will lose your right to get a patent immediately after publication in many countries such as Europe and in India as well. There is absolute novelty, and some other countries. Japan, for example, provides 6 months grace period, and there are few more countries that do that. But the best option is to not publish until you file a patent.
Okay, and as a corollary, if I find something of interest in an academic journal and use it for any commercial product, I do not, the publisher does not get any intellectual property on that paper, and I can freely use that information.
Yes.
Thank you.
Yes, you can do that. If a publisher does not file a patent, and if you create a product out of it, then legally there is no problem, but ethically there could be a problem. Like you will your base the basis of formation of your company and creation of your product will be based on someone else's work. So ethically it is not correct, but legally there is no problem.
Sufyan sir, can I ask one question?
Yes, sir. Please go ahead. Please go ahead.
Okay, I have one thing in my mind that suppose we have one innovation we got somehow we published in some journal, and then we thought of I mean, we are scared that somebody else can, for example, we have developed some technology and we got published without having any patent. So in that case, do you think then any company, for example, in case of pharma companies, can pick up that idea and can start manufacturing that particular product or using that technology. So can they go for that, and can I claim for that based on my publication if he or she, they cannot go for that commercialization, that product?
Many companies can do that, and many companies in fact do that. If an inventor does not protect his invention, company is free to take knowledge from a journal paper and go ahead and create a product out of it. And if that company goes ahead and files the patent application before you, they will even get the patent if the journal article is not published somewhere. So it is possible for a company to take information from a paper and create a product out of it and not compensate the original inventor or the original scientist for it. So the best option, if you believe, or if someone believes that their idea has value, the best option is to go ahead and file a patent application and protect it.
Okay, thank you so much.
Yes, a bit simple query again. What we can patent? It has to be in India, especially a product or a service also. I mean,
Process,
a software or something.
Yes, the Indian patent law says that an invention should be a product or a process. So everything that can be categorized as either a product or a process can be protected through patents. Regarding software is a little different. If I write a code for certain for achieving a certain objective, if I write a code for that, and if I can associate that code with a product, if I can say that this code will be used in this machine to perform this action, if I can somehow relate that, then I can get a patent for a software code as well, for a software invention. But different countries have different approach to software inventions. Some do not like to patent it. Some are little lenient and allow protection if you are able to if you are able to link it to a product. But a software code by itself cannot be protected. You cannot get a patent for it. You can get a copyright for it, but a patent is not possible for an independent software code which is not associated with the product.
I think we can go ahead with the formal vote of thanks now because we already, run out of time. So, but before that, I would like to personally thank Muhammad Najid for, taking time out for our faculty members, for our students. So, on behalf of the Zakir Hussain College of Engineering and Technology, on behalf of the Aligarh Muslim University, we thank you profusely for accepting our invitation and delivering this very important and very useful talk. Thank you very much. We can go ahead with the formal vote of thanks, please. Zoha has to do that.
Yes, sir. Yes, sir. Zoha, please.
Please unmute yourself, Zoha. Yes.
Thank you so much, sir. A very good afternoon to one and all. This is Zoha Kharuwala, student coordinator on behalf of IIC ZSCET, Aligarh Muslim University, and the entire fraternity of the institution. First of all, extend my most sincere thanks to Almighty God for making today's webinar a resounding success. With His blessing and grace, we are able to make this webinar what it was. On behalf of IIC, I extend a really hearty vote of thanks to our speaker, Mr. Muhammad Najid, coordinator of IP Filing Unit Innovation and Technology Transfer, KFUPM, Kingdom of Saudi Arabia, who spared time from his busiest schedule to enlighten us. I am immensely thankful to organizing president, Professor M.M. Sufyan Beg, principal of ZSCET, and faculty coordinator, Mr. Muhammad Imran, assistant professor, IPR ZSCET, and whole IIC club for making seminar successful. I'm thankful to TechIP 3 project also for sponsoring the international webinar. Last but not least, a big thanks to you all who has contributed a lot to for making this webinar successful. Hope you all have written your info in your chat box, and I have noted all that. If anyone has left, can put their information in the chat box so that we can provide you a e-certificate. And this is all from my side. Thank you so much.
Thank you, Zoha. Thank you,
Thank
sir. And thank you, Najid, sir. Thank you very much.
Yeah. So we will end this meeting now, and we'll be in touch, Muhammad Najib, for your further help. Yeah.
Inshallah.
Thank you. My pleasure. Have a good day. Salam alaikum.
You too. Thank you. Bye.